There's a sound that every homeowner fears that it's not a knock. It's not a phone call. It's a knock that doesn't stop. A knock that says, "We're not leaving until you open this door." That sound came to Michael Hartwell on a Tuesday morning in October. He was drinking his coffee. The kind of quiet morning you don't appreciate until it's gone. And when he opened that door, standing there was his HOA president, a woman named Sandra Pruitt. Standing beside her, two men in suits, and a county official holding a clipboard. She looked at him like she had already won. She hadn't. What happened over the next 6 months would drag Sandra Pruitt through every courtroom she had tried to hide from. It would expose an HOA that had been operating as a shadow government inside a quiet suburban neighborhood. And it would uncover a legal truth that Sandra had spent years hoping nobody would ever find. Michael owned the land, not just the house. Not just the structure. The actual ground beneath it, going back over a century in a way that put his property entirely outside the reach of the HOA. She had used to terrorize his neighborhood for nearly a decade. She came to take his house. She ended up losing everything. This is that story. And I need you to stay with me, because what unfolds here is not just one man's fight. It's a blueprint. It's a warning. And for some of you watching right now, it might be the exact story you need to hear. Let's start where all of these stories start. Not with the villain. With the place. Maplewood Estates is a subdivision in suburban Georgia. Modest homes, tree-lined streets, the kind of neighborhood where kids still ride bikes and neighbors wave from driveways. It was developed in the early 1980s by a real estate company called Caldwell Properties. Standard stuff for that era. They platted the land, built the homes. And before they handed everything over to the residents, they filed the homeowners association documents with the county. That association became Maplewood Estates HOA. For the first 15 years, things were quiet. The HOA collected dues, maintained the common areas, enforced the standard rules. Nothing unusual. Then Sandra Pruitt moved in. Sandra bought her home in 1997. Within 2 years, she was on the HOA board. Within 4, she was president. And she would stay president through elections that, as we'll later discover, weren't exactly what you'd call democratic. For over 20 years, what Sandra built during those 20 years was not a homeowners association. It was a control operation. She used dues money to fund litigation against neighbors she didn't like. She created rules mid-year and enforced them retroactively. She levied fines for violations that didn't exist in the original documents, violations she invented and inserted into amended bylaws that she passed in meetings with no quorum. Meetings that sometimes had attendance of only 3 people. All of them on her board. And she targeted people. There is no other word for it. Sandra had a list. Not a literal list, though we'll get to that, but a pattern. Anyone who questioned her at a meeting. Anyone who filed a complaint. Anyone who dared to vote against her. They would find a violation notice in their mailbox within weeks. Sometimes within days. The fine schedule was aggressive. First notice, $250. Second noted, $1,000. Failed to pay, and the HOA would place a lien on your property. A lien on your home. For a cracked driveway. For a mailbox that was 2 inches too tall. For a flower bed that Sandra personally decided was inconsistent with neighborhood aesthetics. People paid. Because in this country, when an HOA places a lien on your home, that lien can eventually lead to foreclosure. Most people don't know that. Sandra counted on that. This is the machine she had built by the time Michael Hartwell moved into Maplewood Estates. In 2016, Michael was a retired civil engineer. 30 years working for the state of Georgia, designing infrastructure, reading surveys, interpreting legal descriptions of land. He bought his home on Lakeview Circle, one of the quieter streets, after his wife passed away, wanting something smaller. Something manageable. He was not looking for a fight, but he was, by nature and training, a man who read documents. When he bought the house, he did what most people don't do. He read everything. The deed, The plat, the title insurance policy, the HOA documents, all of it. Cover to cover, and he found something. Now, I want to take a moment here because this is the part of the story that requires some attention. What Michael found wasn't obvious. It wasn't a glowing red flag. It was so detail kind of detail you could spend your whole life never noticing. Because it's buried in language that most people's eyes slide right past. The HOS Declaration of Covenants, Conditions, and Restrictions, what lawyers call the CC and RS, define the jurisdiction of the HOA, meaning what properties the HOA had authority over. And that definition referenced something called the recorded plat. In Georgia, when a subdivision is developed, the developer files a plat with the county. That plat shows every lot, every road, every common area, all mapped and recorded. The SOS authority is tied to what's on that plat. Michael's lot, Lot 47, on Lakeview Circle, was on the plat. His house was subject to the HOA, but here's what wasn't on the plat. A strip of land along the eastern boundary of his property, approximately 40 feet wide, running the full depth of his lot. This strip, which Michael had always assumed was just part of his yard, was not included in the platted subdivision. It had never been incorporated into Maplewood Estates. It was its own separate legal parcel, and the deed history on that parcel went back to 1921. It had passed through for families before being purchased in 1978 by a man named Earl Whitfield. When Caldwell Properties developed Maplewood Estates, they purchased the subdivision land from various sellers, but they never purchased this strip from Earl Whitfield. It just sat there, attached to Lot 47 physically, but legally separate. And when Michael bought Lot 47, a quiet title search, run by a local attorney, confirmed that Lot 47 and this strip were now under common ownership. With Michael holding clear title to both, he owned a piece of land that predated the HOA, that existed entirely outside of it, that the HOA had absolutely no legal claim over. He didn't do anything with this information at first. He filed it away. He mowed his lawn. He went to HOA meetings occasionally. He kept his head down until Sandra Pruitt put him on her list. It started small. A notice in October of 2019. His gutters were not maintained to community standards. He cleaned the gutters, paid no fine, because he resolved it within the notice period. Fine. January 2020, a notice that his driveway had an unapproved material composition. His driveway was concrete. Standard residential concrete. Had been concrete since the house was built in 1984. He wrote back asking which provision of the CC and RS regulated driveway composition. He received no response. Then the fine arrived anyway. $250. Michael appealed. He appeared at the next board meeting, documents in hand, asking for the specific provision that authorized this fine. Sandra told him the board had broad authority to maintain community standards and the fine stood. He paid it. Because he was picking his battles. March 2020. Another notice. This one about a structure in his backyard. The structure was a garden shed. 8 by 10 feet. He had installed it in 2017, 3 years prior. The CC and RS required approval for structures over 100 square feet. His shed was 80 square feet. He wrote back. Cited the provision. Sent measurements. Included photographs. Fine stood. $500 this time, because Sandra classified it as a second offense related to unapproved structures. There had been no first offense. She manufactured the classification. Michael hired an attorney. His attorney sent a letter to the HOA's management company, a firm called ClearPath HOA Services, laying out the timeline, citing the CC and R provisions, and demanding the fines be rescinded. The management company forwarded the letter to Sandra. Sandra's response was to escalate to over the next 6 months. Michael received 11 violation notices. His fence paint was the wrong shade of brown, despite matching the exact color code listed in the HOS design guidelines. His recycling bins were visible from the street on a non-collection day he had taken them in by noon. His exterior lighting was excessive. He had added to standard porch lights. Each notice carried a fine. Each fine was escalating. By the summer of 2020, the alleged outstanding balance on Michael's account was over $4,000. And then Sandra did something that she had done to 5 other homeowners in the past decade. She filed a lien. The lien appeared on public record in August of 2024. $312. It sat on Michael's property like a brand. His attorney immediately challenged it. But here is where HOA law, particularly in Georgia at that time, was murky in ways that Sandra had learned to exploit. Challenging an HOA lien is not simple. You cannot just call someone and say this is wrong. You have to file in court. You have to prove the fines were improper. You have to fight a legal entity that has been doing this for years and knows exactly how the system works. Sandra had outlasted 5 other challenges. 3 homeowners had given up and paid. 1 had sold their house rather than continue fighting. 1 had won a partial victory but had been financially drained in the process. She expected Michael to fold. She did not know what Michael had found in his documents, and she did not know what Michael had spent the past 8 months doing. He had been building a file, not just on his own case. On all of them, Michael had ending every public meeting, requesting records under Georgia's Open Records Act for all county documents relating to the HOA, talking to neighbors, quietly, carefully, who had their own stories, their own violation notices, their own fears of Sandra. He found the woman on Cypress Drive who had paid $6,000 in fines. Over 3 years for violations, she had never been able to get a clear written explanation for. He found the elderly couple on Birchwood Lane who had been threatened with foreclosure over a fence post that was 6 inches outside the approved setback, a setback that, when Michael checked the county survey records, turned out to be incorrectly described in the HOA's own guidelines. He found the family who had been denied approval for a wheelchair ramp, a medical necessity, and had installed it anyway, and were now facing a lien. He found the meeting minutes that Sandra had been filing. Meeting minutes with the county, as required by the HOA's governing documents. But when Michael compared the filed minutes to the recollections of neighbors who had attended those meetings, the documents didn't match. Votes were recorded differently. Attendance was inflated. In one set of minutes, 3 board members were recorded as voting on an amendment to the fine schedule. 2 of those 3 board members told Michael they had not been at that meeting. Fabricated minutes. Fraudulent votes. An HOA operating as a private fiefdom, with a paper trail designed to look legitimate, Michael organized everything into a binder, indexed, tabbed, the way a civil engineer organizes things. Then he went back to his attorney and sighed. I think we need to go bigger than just fighting this lien. Here is where the story accelerates. Michael's attorney, a woman named Patricia Doss, who specialized in property law and had a reputation for being, in her own words, aggressively thorough, reviewed the binder. She made some calls. She brought in a forensic accountant to review the HOA's financial records, which were technically available to homeowners under the governing documents, but which Sandra had been routinely denying access to 4 years. What the accountant found was not pretty. Over a 10-year period, the HOA had collected approximately $1.2 million in dues from homeowners. Of that, a significant portion was accounted for maintenance, insurance, administrative costs. But there was a pool of money, roughly $240,000, that flowed through a management sub-account controlled almost exclusively by Sandra and the management company. Clear path, invoices that didn't match any services, payments to vendors that, when checked, turned out to be shell companies. In one case, a landscaping contract that paid out $18,000 annually to a company whose registered agent address was Sandra's home address. Operating under her maiden name, she had been stealing from the HOA, not just bullying homeowners, stealing their dues money. For years, Patricia Doss filed 3 things simultaneously. First, A counterclaim against the HOA's lien. Citing improper fines, lack of due process, and tortious interference with property rights. Second, a complaint with the Georgia Secretary of State's office regarding potential fraud in the HOA's corporate filings and election records. Third, a civil RICO filing, racketeer-influenced and corrupt organizations, naming Sandra Pruitt personally, ClearPath HOA services, and to board members who had signed off on the financial documents. RICO is a powerful statute, originally designed for organized crime. But courts have allowed it to be applied to corrupt HOA schemes when the pattern of racketeering activity, fraud, extortion, theft, is sufficiently documented. Patricia had documented it sufficiently the day the filings hit the courthouse. Sandra's attorney called Patricia's office. But here's the part I haven't told you yet. The part that changes the shape of everything. Remember that strip of land, Lot 47, and the 40-foot parcel that predated the subdivision. While all of this litigation was developing, Michael had been quietly working with a surveyor and a title attorney to formalize something, to put on record, officially, what that land actually was and what it meant legally. The conclusion, reached after a full title search, a professional survey, and a legal opinion, was unambiguous. The 40-foot strip was not subject to the CNRS. It never had been. It never could be, because it was never incorporated into the plat. It was held in fee simple absolute, meaning Michael owned it outright, with no encumbrances from the HOA. But here's the deeper problem for Sandra. Michael's house, the actual structure, sat partially on that strip, not all of it. About 20% of the home's footprint extended into the non-platted parcel. Now, you might be wondering, so what? What does that mean practically? It means the HOA's lien was filed against Michael's property. But a lien can only attach to property that is subject to the HOA's jurisdiction. The portion of Michael's property that fell within the non-platted parcel, including a portion of the actual house, was not subject to HOA jurisdiction. Sandra had filed a lien against property she had no legal authority over. Under Georgia law, a lien filé improperly against subject to the association's authority is not just invalid. It can constitute slander of title, a tort, meaning Michael could sue Sandra and the HOA not just for the improper fines, but for damages caused by the clouding of his title. Patricia added a slander of title claim to the counterclaim. When Sandra's attorney saw the survey, the title opinion, and the slander of title claim, together with the RICO filing, the fraud complaint, and the binder of 2 years of documented abuse, she called Patricia again. This time, she asked how much it would take to make this go away. Patricia told her that was not a conversation her client was interested in having. The case went to mediation in the spring of 2021. Then it went to court. I'm going to tell you what happened in that courtroom. But first, I need to stop and tell you something about Sandra Pruitt that didn't come out publicly until the proceedings began. Sandra was not acting alone. ClearPath HOA Services, the management company, was not a passive participant. The evidence showed that ClearPath had actively coached Sandra on how to structure fines, how to document violations in ways that would be harder to challenge, and how to exploit the lien process. In return, they were receiving kickbacks from some of the vendors being paid from that shadowy sub-account. The owner of ClearPath, a man named Douglas Pell, had been operating the same scheme for other HOAs across the Georgia counties. Different neighborhoods, same playbook. Fin, lien, intimidat, said when the Josh's received Patricia's referral, which she made after filing the RICO. They already had a file on Douglas Pell. They had been building it for 18 months. Michael's case became the linchpin because Michael had done something none of the other victims had done. He had documented everything. He had the binder. He had the meeting minutes compared to eyewitness accounts. He had the financial records. He had the survey. He had built the kind of case that gives investigators everything they need to move forward. The AG's office opened a formal investigation in June of 2021. What happened in court? The judge reviewing Michael's counterclaim ruled that the lien was improperly filed. It was struck from the record. Michael owed the HOA nothing. The judge further found that 6 of the 11 violation notices Michael had received were not supported by any provision in the CC and ARIS as written. The remaining 5 were found to have been improperly escalated, with fines assessed in violation of the HOA's own procedures. Michael was awarded his attorney's fees. He was awarded damages for slander of title. The exact amount is sealed under the settlement agreement that followed the court's preliminary rulings. But sources close to the matter have described it as substantial. HOA itself as a corporate entity was placed under court supervision. A court-appointed administrator was assigned to manage operations, review all outstanding fines and liens, and audit the financial records of the approximately 60 homeowners in Maplewood Estates who had received violation notices in the past decade. 37 were found to have been improperly fined. Liens were struck. Money was returned. Sandra Prout was removed from the board. She resigned, technically, the day before a vote that would have removed her. She thought it would protect her. It didn't. The civil RICO case proceeded. It would take another year and a half to fully resolve. I won't get into the complete legal outcome because parts of it remain under court seal. What I can tell you is that Sandra Prout is not involved with any homeowners association today. And Douglas Pell's management company, ClearPath HOA Services, no longer exists. It was dissolved in 2022 following the state investigation. Now, I want to talk to you for a moment about why this story matters beyond Michael Hartwell's yard. Because this is not a rare story. It's a common one. And the only thing that's rare about Michael's outcome is that he won. There are approximately 365,000 homeowners associations in the United States. They govern roughly 74 million Americans. That's nearly a quarter of the entire country living under the authority of a private organization that is not elected by the public, not regulated by any federal body, and not subject to most of the constitutional protections that govern actual government entities. The HOA can't throw you in jail, but it can take your house. And in most states, it can do so with remarkably little oversight. The power to lien, the power to foreclose, the power to fine. These are extraordinary powers to vest in a private entity whose leadership is often, in practice, whoever wants the job badly enough to show up to a meeting and raise their hand. Sandra Prout wanted the job. She raised her hand. And nobody stopped her for 20 years. This is the systemic problem that individual stories like Michael's illuminate. Not just one bad actor, but a structure that is perfectly designed to amplify bad actors, where the people who most want the power are often the people who should least have it, where the rules are complex enough to confuse, and the enforcement mechanisms are strong enough to destroy. There are homeowners all over this country right now, sitting on violation notices they don't understand, paying fines they're not sure are legitimate, afraid to push back because they don't know what pushing back might cost them. Some of those people are watching this video right now, and I want to tell you something directly. The most powerful thing Michael Hartwell did was not hire an attorney. It was read his documents, every word, before the problem started. So that when the problem started, he was not starting from scratch. You have a right to see your HOA's financial records. In most states that's required by you right. To meeting minutes, to board member contact information, to a complete copy of the CC and RS and any amendments. You have a right to appeal fines, to our hearing, to an itemized accounting of every charge on your account. And here is something almost nobody tells you. If you buy a home, do a title search that goes back further than the HOA's formation date. Have a surveyor verify that your lot boundaries match what's in the plat. Because what Michael found was not unique to his neighborhood. Survey discrepancies, irregular parcels, land that predates subdivision, these exist everywhere. And most homeowners never know because nobody told them to look. The law is full of protections for property owners. But those protections are only useful to people who know they exist. I want to close with something that happened after all of this was over. Michael Hartwell. In an interview with a local Georgia paper, I'm not going to name the paper because I don't have permission to reproduce it directly, said something that has stayed with me since I first read this case. He said, I didn't fight because I wanted to fight. I fought because I realized that if I paid that first fine without asking why, I was telling her it was okay. And once you tell someone like that it's okay, they never stop. He was right. Sandra Prout had lasted 20 years because 20 years of people decided the cost of fighting was higher than the cost of giving in. And every time someone paid without asking why, she got bolder. That's the mechanics of this kind of abuse. Not courage. Not malice, even, in its pure form. Just the accumulated momentum of unchallenged power. Michael broke the momentum. Not this. Money? He didn't have unlimited resources. Not with connections. He was a retired engineer living alone. He broke it with something that is available to everyone who is willing to use it: attention, documentation, persistence. He read the documents. He asked the questions. He kept asking, he kept the receipts. And when the moment came, he had everything he needed. One of the neighbors on Birchwood Lane, the elderly couple with the wheelchair ramp, received a letter from the court-appointed HOA administrator in the fall of 2021. The letter said that the lien on their property had been struck, that all outstanding fines had been waived, and that the installation of their wheelchair ramp had been retroactively approved. They had been fighting Sandra for 3 years. They had spent over $12,000 between fines and their own legal costs. They got none of that back. It wasn't part of the settlement terms they were subject to, because their case predated the consolidated action. $12,000. For a wheelchair ramp that should never have been challenged in the first place. That family is the reason this story needs to be told. Not Michael's victory, though that matters, but the thousands of people who don't get a Michael Hartwell, who don't have the engineering background or the patience or the binder, who just get ground down. The underground exists because the mainstream doesn't talk about this. Because an HOA foreclosure on a house worth $300,000 over an $800 fine doesn't fit the narrative. We've been sold about private governance and community standards and property values. But it happens. It happened. 2 people in Maplewood Estates. It is happening right now in subdivisions across this country. Now you know. If this story opened your eyes, stay with us. Because this is one of hundreds. The machine runs deeper than one subdivision in Georgia. And we're just getting started. Hit that subscribe button if you want to go deeper with us. Leave a comment. Tell me if you're dealing with something like this, or if you've seen it happen. And share this with someone who needs to hear it, because the first weapon against this kind of power is knowing it exists. I'll see you in the underground.